Hello, I am Christina Henderson, Executive Director of the Montana High Tech Business Alliance. Welcome to our webinar, The Corporate Transparency Act and How It Will Affect Montana Businesses, co-hosted by Parsons, Behle, and Latimer. We are recording this session and the video will be made available online and emailed out to everyone who registered. Today, we are pleased to welcome our guest presenters from Parsons, Behle, and Latimer, attorneys Ross Keogh and Tyler MacKay. We will be conducting this webinar in a Q&A format with time at the end for audience questions. If you have questions for our speakers today, please type them in the chat or raise your hand and turn on your microphone. So Ross Keogh is a shareholder in the firm's rapidly growing Missoula, Montana office. His practice focuses on helping clients create and manage tax-efficient businesses and capital syndication, particularly in the context of startups, real estate, and the Opportunity Zone incentive. Tyler MacKay works closely with startups, founders, and their investors to source capital, innovate, and grow rapidly. In addition to representing clients in initial seed stage and later stage financings, company exits, and security issues, Tyler brings a solutions-focused perspective to clients' day-to-day transactions and legal issues. I'm now pleased to turn the floor over to Ross and Tyler.
Thanks, Christina. And I think Tyler had just joined and is getting his camera set up, so I'll let him pop across. And we'll probably give everybody just a couple more minutes to join as appropriate. So I'll just provide a little more background on the firm, and then we'll jump into the meat of the presentation. Just to make sure I'm confirmed here, can everybody see kind of the nuts and bolts main slide presentation? Is that coming across correctly? Is it sharing well? Awesome. And I hope everybody got their snow shovel today in Montana, and I see Tyler's just been able to join us as well. Great to finally have some moisture here, and thank you everybody for participating in the webinar. So we're going to kick it off here. I don't know, and it's hard to do a show of hands who's heard of the Corporate Transparency Act. It's something that's been around for a minute, but just went into effect here in 2024. So a little bit about Parsons. We're a regional law firm. We have offices in now 5 Western states. We just opened a presence in Wyoming, and also here in Montana, offices in Missoula and Helena. I do need to cover the legal disclaimer. This presentation is based on available information as of today, but everyone must understand that the information provided is not a substitute for legal advice. This presentation is not intended and will not serve as a substitute for legal counsel on these issues. All right, so why are we talking about the CTA? What's important, and why is this relevant to you? So beginning on January 1, 17 days ago, every reporting company, we'll talk more about what that definition means, must file and report with the U.S. Treasury's Financial Crimes Enforcement Network. This is FinCEN. This is the arm of the Department of Treasury that is actually allowed to carry guns, unlike the IRS now. And it must report information about each of its beneficial owners. We're going to talk what beneficial owners mean, what the FinCEN database is, and the reporting company in detail throughout the presentation. There are an estimated 32.5 million entities that need to register and report in 2024. And there are substantial penalties for the failure to not comply, including fines up to $10,000 and 2 years in prison. So if you're a business owner, chances are you'll need to report any LLC that you're associated or affiliated with. We're going to let you know today what those requirements are and how you can accomplish your reporting. So the act went into effect on January 1. We think for most businesses, this will be fairly easy, but it is a substantial compliance burden if you have a more complex business structure, such as a multiple tier partnership. Registration can happen at this link, fincen.gov/BOI. There's been a lot of registration already taking place. In the first week, FinCEN said some 600,000 entities registered with the act. That is 1/6 of the pace that is needed for all entities to get registered on the act. And then we'll talk just very briefly today about sort of our approach to compliance, if anyone is interested in support about how we're going to facilitate that as part of our presentation. So Roadmap for today, we'll overview the CTA. Feel free to drop questions in the chat as we go. Tyler and I will either answer those at the end or respond iteratively. We're going to talk about how we see the CTA affecting deals and just general corporate evolution. We'll provide a quick overview of the way we're approaching compliance, and then have plenty of time for questions as appropriate to help you with your CTA compliance. Tyler, I'm going to turn it over to you here.
All right. Thanks a lot, Ross. And it's great to be here with everyone. Thanks for having us. So when it comes to the CTA basics, and Ross, if you wouldn't mind, jump to the next slide here. There we go. All right. So the Corporate Transparency Act was issued as part of the National Defense Authorization Act in 2021. So the Corporate Transparency Act itself has been around for several years. There was an attempt by President Trump to veto the CTA, but that veto was overridden. All indications show that the CTA is here to stay for at least the foreseeable future. And following 2021, the overall act being passed in September of 22, FinCEN issued their final rule, which provided the meat and potatoes of the CTA and how reporting was to be accomplished there. And as of January 1st, 2024, the CTA is in effect. In addition to it, FinCEN's new reporting system called BOSS, that is also live as of January 1st, and so we're now under reporting obligations. Next slide, Ross. So when it comes to CTA registration, the question is, basically you've got two questions: who needs to report, and two, what needs to be reported. So on the topic of that first question of who needs to report, there is really a 1.5 part analysis, right? There's one key question, and that is for domestic entities. So United States entities, was there a document filed with a state or similar office, like a Native American, like a tribal agency or something like that, right? Was something filed with that group? So for domestic entities, was the entity registered or organized via filing that document? Or for foreign entities, so non-US entities, has that entity registered to do business in the United States by filing a document with a state or similar agency? If yes, then we are likely a reporting company. I say likely because there are some exceptions or exemptions to filing, but those are few and far between, and largely inapplicable to the vast majority of entities that are filing. And we'll get to some of those in a later slide. So next slide, Ross. So assuming we are subject to reporting under the Corporate Transparency Act, what needs to be reported? Basically, there's two sets of information. One is company information, business address, the company's EIN, et cetera. And the other set of information is beneficial ownership information. And that's the key subset of information that we're focusing on today. When it comes to the beneficial owners that must be reported, basically there's two types of beneficial owners there. One is any individual who exercises substantial control over the company, or an individual who owns or controls at least 25% of the ownership interest of the reporting company. And when I say individual, should there be, for example, an LLC that is owned by another LLC, we're looking through, basically we're reporting that top LLC, but we're looking through to identify the individual owners, and that's the key impetus here is that we're looking to identify who are the individuals who exercise control or own the company. Next slide, Ross. So when it comes to substantial control, who does exercise substantial control? So we're given some guidance in the regulations here. The first is being, senior officers, anyone that may hold the role of chief executive officer, operations officer, anyone in the C-suite. Vice presidents also likely fall into that category. And then there's a large bucket for individuals who can, who exert substantial influence. Substantial influence being the key word. So who's making important decisions about the nature of the business, the disposition of key assets, investments, compensation schemes, who can authorize entering into significant contracts, etc. So that first group is, again, individuals with substantial control who are exerting substantial influence. There's also a concept here of indirect substantial control. So, for example, trustees of a trust, should a trust own, for example, 50% of an entity, we're identifying the trust, but also we're identifying the trustee as the individual that has control over the trust, and therefore that beneficial ownership. We're reporting board members. We're also including certain financing arrangements that provide indirect substantial control. If there's a more complex corporate chart where you've got several entities stacked on top of each other, we're reporting individuals up the line who may be exerting that indirect substantial control. And then they have a bucket here in the regulations for any other contract, arrangement, understanding, relationship, or otherwise whereby an individual exerts substantial control. So when it comes to information, once we've identified that, one, the company is subject to registration, two, we've identified the beneficial owners and who must report, then we're left with the question of what must be reported. When it comes to the company itself, we're reporting the full legal name, any trade names or DBAs, the complete current street address, company state, tribal, or foreign jurisdiction of formation, or if it was a foreign entity, the state with which they registered, and then the company's taxpayer identification number. There are considerations that some single member LLCs are disregarded for tax purposes and don't have an EIN. The regs do account for that. Next slide. When it comes to the information that beneficial owners must report, and this is when we're talking in terms of substantial compliance obligations, this is likely where the majority of the work is going to take place. So, for example, you have an entity with four, for example, an LLC with 4 members, and then also 2 or more managers. Not only are you going to have to report them, but you're going to have to provide the following information for them as well. Their full legal name, date of birth, complete current address, which can be an individual's residential address or a company's street address. And then a unique identifying number from a government agency issuing that number, which is basically, we're talking about non-expired U.S. passports, driver's licenses, social security cards, or for foreign individual is the individual that's being reported. It will be a foreign passport, along with an image of that document from where the identifying number comes from. So for the majority of people on this call, it's going to be your driver's license and also a copy of that. And so all of this has to be collected from each of the beneficial owners that are to be reported. Ross will talk later on about a concept called of a FinCEN identifier, which, rather than individuals providing all of this information to the company and providing social security numbers and sensitive information, an individual is able to personally go to FinCEN, provide this information to FinCEN directly, obtain an identifying number from them, and then providing that to the company instead of providing all this information. But Ross will get into that in a little bit more detail later. Should there be willful violations of this Corporate Transparency Act, there are teeth here. We don't know what enforcement looks like yet, but we imagine in 2025 there was going to be quite a bit of enforcement, and we'll start to see what that looks like. But there are penalties of not more than $500 per day for willful violations, up to a total of $10,000 or 2 years of imprisonment. And so, as the kids say, the don't sleep on the Corporate Transparency Act. Will there be reporting obligations? Yes. Will there be a burden to do so? Yes. But it is important that we're aware of these things, and that we comply with the timelines within those times in order to avoid some of these penalties. And with that, I'll turn it over to Ross to speak a little bit more about how we're thinking about the Corporate Transparency Act in terms of deals and workflows and such.
Thank you, Tyler, for that overview. So just to recap, if you have an entity organized or registered with the Secretary of State, it will likely need to report. We'll cover some of the exemptions from reporting in this presentation, and the entity needs to report its beneficial owners. There are two species of beneficial owners. Those are ones that own more than 25%, or those are individuals or entities that exercise substantial control. As Tyler said, that can be indirect or it can be direct. So I'm going to talk about how that all probably interfaces with your deal and give you some just general examples of what this means in the context of business. So the first important distinction that we need to make is there are two vintages of entities. There are entities that were formed and organized before December 31st, 2023. We call those pre-24 vintage entities, and there are all other entities that have been organized starting in the last 18 days. If there's a new entity that is formed, the Act imposes in 2024 forward an additional reporting requirement. In addition to identifying the beneficial owners, you also have to identify the company applicant. I'll talk with specificity on the next slide of what the company applicant is, but it's generally the attorney or the individual that formed the entity. Registration needs to occur for new entities, not by the end of 2024, but within 90 days of the entity being formed. So that means the first time, the first reporting obligation under the Act is likely March 30th, April 1st, 2024 for any entities that were formed on day 1 of 2024. If you form an entity today, you're looking at about April 17th, April 18th to make sure that that entity is registered and fully reported with the CDA to be in compliance with the Act. That 90-day reporting window for new entities is reduced to 30 days starting in 2025. So it's kind of a warm-up 90-day period for new entities right now that'll drop down to 30 days. If you have an old entity, though, you have until the end of 2024 to get that entity registered. And we think it's likely that if you were to dissolve an entity that you don't need anymore, that entity won't have a registration obligation in 2024. This is an area that we'd love for FinCEN to issue a specific frequently asked question on. I should say that our advice, our counsel, is based off kind of 3 different materials. One is the underlying Act, well, really 4. The other is the regulations that FinCEN has issued. The third, which are quasi-regulations, are the FAQs that FinCEN is issuing periodically. I was given a presentation on Friday. During the presentation, they issued new FAQs. That hasn't happened on today's presentation or this week, but I'm anticipating some more FAQs later this month. And then the fourth is the actual application itself has additional explanatory materials on it that sometimes help clarify some of the open issues. And so part of the posture that we're in now is we're waiting a little bit to do registration where in areas that we don't have clear guidance, hoping that FinCEN will clarify some of those issues for us prior to having to register the entity going forward. So let me talk a little bit about why this is happening. I don't know if any of you have formed Wyoming LLCs or have worked with Wyoming LLCs, but this is the article of organization that you complete in Wyoming. You identify the name of the limited liability company. You provide a registered agent and an address. You provide a mailing address. You provide a principal office address, and someone needs to sign this form as the organizer. So if a client reaches out to me to form a Wyoming LLC, I sign this form as the organizer. This is the only public document other than annual reporting, which provides the same information that provides any indication as to who owns or controls the entity. And from this document, you don't learn anything about who owns and controls the entity other than the attorney that formed it, and its principal office address. That in Montana, it's different. In Montana, if you form an entity, you have to identify the principal agent, whether it's the manager or the members, depending on if it's a manager, member managed LLC, similar to other corporations and so forth. I'm pretty sure that when you form an entity in Bermuda or your favorite sort of tax preferential jurisdiction, that you have to provide more information than you do in the state of Wyoming. Lots of concerns about money laundering, fraud, and so forth. And so the CTA is intended to be a way to require some level of beneficial ownership reporting that's uniform across all 50 states. Very similar to what you see in Europe, less rigorous than what's required in many jurisdictions there in terms of ownership reporting. So the US has been a little bit behind in this. This is catching the US up in many ways to kind of national standards on understanding who owns and controls entities. So back to the concept of company applicant. This probably doesn't relate to many of you who aren't actively forming or controlling new entities, but the company applicant, which needs identified for 24 entities going forward, is the individual who directly files the document. So if I'm inputting the information on the Secretary of State and I'm clicking file, and with our current Montana Secretary of State interface, you have to attest under penalties of perjury that you're authorized to file. That individual is most likely a company applicant or anyone who directs or creates the documents that need to be filed. So even if I'm an attorney and I fill out articles of organization and I say, hey, client, just go file these, I'm still a company applicant. I need to identify with FinCEN. FinCEN issued new FAQs on Friday that further clarify who is the company applicant in some particular situations, but it's hard to avoid it if you're involved in organizing or forming the entity. So if you are doing this for anybody in 2024, just be advised that you're going to need to be identified as the company applicant. And if the company applicant fails to provide the company the information they need to report the entity, the company applicant is liable for CTA reporting. So some real potential teeth there if you are serving in this role and you fail to comply with your obligations. Tyler mentioned this concept of a FinCEN identifier. We anticipate that we'll be seeing a lot of FinCEN identifiers moving forward. We're going to see this on cap tables, and that this is going to be kind of the currency that everyone identifies themselves for purposes of reporting. So what it is it's simply a unique identifying number. I think it's 12 digits that FinCEN is going to issue. It's fairly easy to obtain a FinCEN identifier. You can create a login.gov account, and then you provide the same information that you would otherwise provide to be a beneficial owner. Our counsel is that anybody that's going to have an interface or a nexus for beneficial ownership reporting with more than 2 entities needs to obtain a FinCEN identifier. So for instance, as I'm going to be the company applicant on a number of entities because I help form and organize them, as does Tyler. Tyler and I will be securing FinCEN identifiers. Here's the information. Again, it's identical to what was previously needed for beneficial ownership reporting. I do want to call out, though, that you have to provide a picture of your driver's license, and you have to provide the issuing jurisdiction of the driver's license or the passport, whatever photo ID you use. We don't know if you will be required to update that picture when you get your passport renewed or when it expires. The number doesn't necessarily change. So that's one thing we're kind of tracking and we'd like guidance or clarity on. But there's an obligation of the Act, which is across all reporting, that if there are any changes need to be updated and logged within 30 days of the change taking place. And so part of the reason and the impetus and the benefit of the FinCEN identifier, if I'm an entity, is to hopefully outsource that and identify that updating requirement to the individual beneficial owners. So if the manager of my LLC changes their physical address, it's just a matter of them updating their FinCEN ID. I don't need to go re-update my beneficial ownership filing for that underlying entity. That's something we haven't gotten as much clarity from FinCEN as we want, that the company can kind of rely on the FinCEN ID and doesn't need to police that it gets updated. We're also managing that contractually, ensuring that there is coordination or an indemnification for members and managers to keep these updated and correct. But something to watch if you're looking to be in compliance with the Act. It's a lot easier, right, to provide my FinCEN ID than a photo, my passport, my passport number, my personal address to someone that I organize an entity for. And so this helps to deal with kind of the exchange of confidential information for individuals to get the FinCEN ID. As I discussed, this kind of 30-day update window that the individuals need to maintain and keep their FinCEN up to date. I want to talk a little bit about trusts. We oftentimes see trusts as owners of companies, whether through estate planning or some other mechanism. The rule does provide us some indication of who would be the owner of a trust, right? A common law trust does not need registered under the Act as a reporting company unless it is organized like a Delaware statutory trust. But typically, we're going to look towards the trustee as being a beneficial owner, as long as anyone who has the ability to control or dispose of assets. So in the parlance of estate planning, we think of that maybe as a power of appointment or the right to revoke the trust or otherwise withdraw the assets. Treasury has indicated that on both this topic and how to manage the situation of when someone dies, the decedent until the estate gets set up and the 30-day updating obligation, they'll be issuing additional guidance on that matter coming out. So where does this all go? There is what's known as the BOSS database. This is a beneficial ownership registry. It is has the same underlying architecture as the Know Your Customer database that the banks are now required to use in the Bank Secrecy Act. And there's the potential that once a rule that was issued in December is adopted, that if you've registered beneficial owners for purposes of CTA compliance, that you'll be able to port those to the Know Your Customer database to facilitate account opening and so forth. Don't quite know how that's going to work yet, but it's out there and it's on the horizon. And so there are potential upsides to this registration process from business ease and formation. Are you exempt? There are a handful of exemptions. It's worth knowing about them. Except for one or two, we don't see them having much value to most individuals and entities. The first one, just to keep on your radar, is sort of the forgotten entity exemption. This is an entity that is not engaged in active business. It existed prior to 2020. So really pretty serious long-term memory loss for this to apply. It never received funds over $1,000 and doesn't own an asset. If you can meet that exemption, you know, FinCEN's not going to hold whomever may own that entity liable for failing to report. Otherwise, if you don't meet those criteria, that entity does need a report or needs to get wound down ASAP under the Act. There's also a wholly owned subsidiary exemption. It's easy to think about this exemption as saying, if I have a wholly owned subsidiary, it's exempt from reporting. That is not the exemption. The exemption requires that the parent, the owner, be exempt. And if it's exempt, all its subsidiaries also get to be exempt. It's not just that I have a wholly owned LLC that's exempt from reporting. If I'm otherwise required to report and there's a wholly owned LLC, that wholly owned LLC also needs to report, even if it's disregarded for tax purposes. I think that really underscores how broad reporting is under the Act and how painful it's going to be for lots of us who, you know, in any given week might set up 4 or 5 LLCs. There's a lot of work to be done to bring everything into compliance. The other exemption, which is helpful in some ways, is that if you have an entity that can be classified as a large reporting company, it has to employ more than 20 people, has an operating presence in the US, and has a federal tax return with more than $5 million in gross receipts. So a couple things. A new entity can never be a large reporting company, right? Because it hasn't filed a tax return showing that it has $5 million in gross receipts. We think in many cases, there's also no way to affirmatively claim the exemption. So the only way to claim an exemption is to file a beneficial ownership report and then subsequently come back and amend and indicate that you now qualify for the exemption. It would be helpful and I think appropriate for Treasury to find a way for someone to register and to claim an exemption without having to file beneficial owners. I think that will avoid mismatching and make the enforcement easier. But they have yet to do so. But if a new entity is formed, it registers, and then later it has a tax return against these employees, hits these thresholds, they can subsequently just log in, and indicate that it's now exempt and indicate and avail itself of the large operating company exemption. There are a bucket load of other exemptions that are highly technical, that make some sense. The one that I would draw out is definitely nonprofits. If you have a 501c3, the entity is exempt. But there are a variety of other entities, like homeowners associations and so forth, that have been organized but may not be a nonprofit, that won't be exempt, they'll be required to report. And then there are exemptions appropriate to businesses that are in highly regulated areas that would really probably have no problem at all complying with the act. And also governmental authorities are broadly exempt from the act. The law firm lobby must have been asleep to not get us exempt from the act on that date, but there we are. Okay, so macro picture, we have 1 year to report registration for pre-2024 entities. Reporting needs to be done for new entities within 90 days. If you have a change to an entity's reporting structure or ownership, you have 30 days to update it. So if a manager of an LLC changes, once that entity is reported, you have 30 days to update it. You don't need, our read of the rule is that you don't need to report an entity now, and so you can report an update later. Let all the dust settle in 2024 and just make sure the entity is reported correct as of its first report, not with all the iterations in 2024. It's going to be very challenging in multi-tiered ownership structures that unfortunately we deal a lot with. We do not yet have the guidance we need from Treasury to appropriately and accurately report those structures, where you have a fund that's involved in owning a lower tier entity and would be a beneficial owner for purposes of the act. The FinCEN identifier is going to be key for most individuals that are actively engaged in business. It's probably worth individuals now logging in, securing one, and being able to use it and distribute it to do their reporting. And we're expecting a lot of matching. We're expecting in 2025 that FinCEN is going to match the EINs they've collected against tax returns to see which entities have and haven't filed, and that there's going to be matching with the Secretary of State's databases. I'm also anticipating that on 2025 tax returns, there are going to be new questions added to the forms where the CPA that's completing the return will have to indicate whether or not the entity has complied with the CTA. And so we as professionals, also in the context of other professional rules, are anticipating that we might start needing to see FinCEN reporting information as part of our client engagement and introduction process to ensure that we know A, who owns the client, and B, that the client's up to date in its reporting. Expect that that's going to also be something that's a standard contractual covenant and warranty, especially in deals where you're buying stock or assets due to the potential liability under the act for failing to report. Just a real brief kind of preview of the way we're helping our clients. We don't view CDA registration as an existing legal service. So if you're a client of Parsons Behle, you'll need to specifically engage us if you want us to help you with CTA compliance. We think that for a lot of our more complex business structures and clients, that they are going to be actively and frequently updating their registration across their whole chain of entities with FinCEN whenever a deal happens or a change takes place. And so our approach is to build a mirror database on our system that once FinCEN makes their API available, that we'll just be able to make the change in the mirror database, and that all affiliated or webbed entities will automatically have updated reports filed with FinCEN. Other law firms are probably going to be taking a similar approach, especially the larger firms. We're fortunate at Parsons that we, especially kind of given our location in Salt Lake and the kind of tech hub there, that we have some staff that's very talented in programming and logic creation. And so we've partnered with a product to help build out logic that we're able to work with clients pretty seamlessly to gather the information that we need to help them determine who they need to report and to ensure it's done correctly in the context of kind of an iterative legal product. Here's sort of an example of our input form that we would send to clients where they would provide some information for us if they don't have and to collect a FinCEN identifier. So we see using this sort of web-based product as a good way to securely gather the information for a client reporting company from its beneficial owners without having to exchange that information directly with the client and just given some sensitivities and privilege there, we think is going to be very helpful and critical going forward. Well, I think we hit our time for questions, and so I see one in the chat, but I'm gonna leave the leave the presentation. Great. So thank you for the question about sort of fractional CFO services. And feel free to raise your hand or drop a question in the chat if you have any about the act. Yeah, so this is a great question, right? So someone is providing a contractual service to an entity. Are they, I think there are two parts to it. Are you, one, a beneficial owner? And are you, two, do you have an obligation as the company's fractional CFO to ensure that the company complies? You know, both of those are going to be a function of your contract and your scope of engagement. And I think for a lot of professionals that are helping businesses, it's very important to clarify roles and responsibilities. And the CTA probably gives you a good time to do that. And so I would think that if, you know, especially if you're handling Secretary of State annual reporting, that the client would think naturally that you're also the sort of the CTA reporting compliance person, and that's in your bucket of responsibilities. But that's a conversation to have with the client, and I think it would be timely to have that conversation now. The other question is, are you a beneficial owner? And, you know, as Tyler pointed out, that test can be very mushy, right? It's both a function of your contract with the entity. Does it give you the type of agency that the act looks for? Can you make major decisions? Can you control the direction of the company? Or is it more just clerical in that you are simply recording the ledger of the company, preparing financial statements and so forth, but you don't have decision-making authority? That's sort of one tier. The other tier is it can be indirect. So if you retain any or have any quasi or even non-contractual decision-making, then you're probably a beneficial owner. I would think that we don't know any harm yet in being identified as a beneficial owner, but I think it's important to determine what side of the fence you are on and take a consistent reporting position and to ensure that your contracts reflect that. And may even be appropriate to say in a sentence in your contract that I am not a beneficial owner and the company identifies me from any issue of reporting and so forth and agrees to do their CTA reporting. That may be overkill, but I think having that conversation with the client early would be appropriate. Does that help with the question? Okay. Anything else in chat? Anyone like to ask?
Nothing listed. Feel free to type in chat if anyone has anything or to speak up and ask questions. One question I would have on the part of maybe very small businesses, if they're used to filing their own reports, for example, annual reports with the Secretary of State, are the forms required for compliance with the Corporate Transparency Act simple enough that someone with a relatively basic business would be able to also complete this reporting themselves?
Yeah, so let's just say you have a husband-wife LLC that owns a rental property. I think you can get through it pretty quickly and do your reporting. You know, you'll need to decide if you want to establish a FinCEN ID for the owners. I think that's the first kind of decision tree. And so if this is your only entity, the answer is no. And then it's just really a matter of knowing those elements that Tyler had identified, right? Do I know the formal legal name? And it's always a good idea to get onto the Secretary of State and, you know, make sure you type it exactly the same, you know, put the comma in the right place, capitalization be correct and so forth. And then you should know your principal address. One thing to note is a principal address can't be a PO box. So make sure you get that correctly in the form. And then your employer identification number, you need that piece of information. And then you just need to identify the beneficial owners. And it doesn't require that you identify how someone's a beneficial owner, whether it's voting or substantial control. So you don't need to worry too much about distinctions between, that's right, Tyler, right? Between manager and member managed. It's pretty easy just to identify those individuals that are associated with the entity, whether it's through agency or through ownership. And then you need their information, address, a picture of a driver's license, and the number that's on it. And you're good to go. So the form was pretty intuitive. It has some little question boxes. I would think a lot of people can get through it pretty easily. It's going to take some time. The good thing is once you're fully filed, you're done. You don't, and there's just a question in the chat to this. You don't have to update it every year. You don't have to make any changes. If nothing changes in your business structure, you're good until a change takes place. We have yet to amend a form, but it didn't require that we have a login associated with the entity or perpetually associate with us with the entity. So anyone should be able to log into the entity, make the change as long as they're willing to attest that they have control over it, and update the beneficial ownership reporting. That didn't seem like the best solution to me, that anyone could get onto my entity and make changes. So I'll be curious if there's not an iteration made there going forward. But yeah, it felt fairly intuitive. I have not, been impressed with the guides and the guidance that Treasury has provided to help business owners. I think, and even a lot of the third-party services that we're seeing out there. One of our competitors just released this big tool about like, well, figure out if you're exempt. I don't know if that's really helpful for most businesses. I think most businesses just probably are going to register unless you can really identify one of those exemptions. And so, unfortunately, there's not a lot of good help out there right now to help businesses just at the most basic level get through it. I'm also, just full disclosure, fairly frustrated with the Montana Secretary of State. We've seen great correspondence from other Secretary of States alerting business owners of this obligation, giving them resources and guides to follow. I just saw the Idaho Secretary of State has a splash page discussing it when you log in. Montana's done nothing. Despite multiple emails over the last couple of weeks reminding business owners to file their annual report, there's been no communication from the Montana Secretary of State. I've reached out to the office. I've suggested that it's important that we have communication on this issue from the Secretary of State, and have not gotten a response from the Secretary. So I think it's a gap, and I'm hopeful that we'll see some more resources and information out there to help business owners, which is part of the reason Tyler and I are trying to get the word out. Yep.
We've had a couple other questions posted.
Yep.
So was it within 30 days that your FinCEN ID would need to be updated, for example, if you moved?
Yes. Yep. That's our read of the act. And what we're hopeful is that by the owner of the FinCEN updating their FinCEN ID, that is also sufficient for the underlying entity that's reporting that FinCEN ID. We believe that to be the case, but it would be helpful to have a little more clarity on that. And the FinCEN unfortunately hasn't told us what we need to do if your driver's license changes or is updated, or you get a new one, if you have to also update it. I would probably, I haven't tried to do that yet in the database, Tyler. I don't know what that looks like. But I would, if it was my own entity, I would probably do that for it, just to make sure that I'm as compliant with reporting as possible. But great question.
Are there, you'd mentioned that we maybe have a gap right now in available information for Montana businesses, but are there resources that you can point to where folks could keep updated with as more clarity is provided and more frequently asked questions are answered?
Yeah, the FinCEN website has a list of FAQs with the date they're published. I mean, we get an email whenever you can register to get more information. That's really the repository to check how FinCEN's issuing additional guidance on particular types of questions. Other than that, there are materials. There's some guides that FinCEN has produced. Tyler and I have not found those. I think it's fair to say particularly helpful, especially on kind of some of the more complex questions that we're encountering. So there, if you don't have one of these very easy entities to report, I think it's completely appropriate to take a wait and see approach to what's going to happen with the act. There is one lawsuit that's attempting to enjoin the enforcement of the act. I haven't gotten an update on that, but obviously the acts went into effect. It wasn't enjoined. I don't think that's likely. I do think there are some election issue dynamics here that could come to play. where this does become maybe more of a political issue, this idea of registration, and who knows where that leads to. But the database is built. It's an obligation that businesses need to face now and register now. And I think under any political scenario, it is impossible that this act would be repealed before the end of the reporting obligation, which is the end of 2024. So it's something I just don't think that's a realistic expectation that somehow this will change. I think we maybe could see something in 2025 that clarifies a couple issues in it, just depending on how businesses are able to comply. And I do think it's possible that FinCEN may issue some additional rules that provide businesses additional reporting latitude. But I think because of the election dynamics, I don't see the deadline to report getting extended past December 31st, 2024, absent a catastrophic failure of the reporting infrastructure and database. Tyler, do you have any broad observations to add to that? Else you want to comment on? Okay.
So if someone is part of a relatively complex collection of entities or would have more complicated businesses to register, given what you're seeing, would you advise them to get started now to work through those issues? Or is there any benefit to waiting to see if more of the details get hammered out in the early part of the year?
Yeah, so what we've been telling clients kind of from day one, over the last couple of years, is you should do two things. You should make sure that you have a corporate org chart that is accurate, up to date, that identifies the information at each level that you would need to report. And I mean, I think that's good corporate practice anyways, but which state is this entity organized in? What's its mailing address? What's its physical address? What's its EIN? Who is it, manager, member managed, or who are its officers and directors? Who owns the equity in the entity, and so forth. So I would, there's some great tools now out there, some great charting tools that make that very helpful to put that map together in a way that's accessible and so forth. And frankly, it's one of the first things we ask clients when we work with them is, do you have an org chart? Can we see it? Because it lets us very quickly understand your corporate and efficiently understand your corporate structure. And as part of that, you would start to gather the FinCEN IDs of individuals on that chart that will need to be reported as beneficial owners. So I would get all that in place. And then I would probably wait, if you have multiple tiers, to figure out how to accurately and correctly report the tiers. The issue, and it's an issue that we're running into, is we have an entity and it's owned by a fund and it's owned by a bunch of others. And we're going to be forming a new acquisition company for our client. And we're going to form it today. And so we are now on a 90-day clock to report that entity's upstream beneficial owners. And, our communications with some of the largest law firms in the country have indicated that there's a lot of ambiguity around that. And I think there's going to be a lot of hestation when we need to, file for this small entity that's doing a very specific thing in, Phillipsburg, Montana, that I need to now associate that entity with someone in New York City who is used to having a lot of anonymity because they are the parent of the hedge fund, or they are the officer and director of it, which controls our intermediate client, which controls this entity. But Treasury has indicated, and they continue to indicate as of last Friday, that that's the result they want. And so we'll see if that is the result, and we'll probably wait right up until then. But failing for that entity to report, maybe it even trips some of the criminal implications of the act. So I think that's a really challenging and unfortunate issue for us to have to manage in this deal cycle in 2024.
Russ and Tyler, you're both working quite a bit with startups and financing, whether it's seed stage, later stage. How do you see the Corporate Transparency Act impacting both investors and venture capital firms, and also companies that may be looking to raise money?
Tyler, do you want to offer any observations? Yeah.
Yeah, I mean, when it comes to VC money coming in, usually that's going to be a minority stake, right? And so that, they may not be required to report on the CTA. However, there are also very frequently control obligations, restricted covenants that a VC, whether it's selling a company, raising additional money that the VC has to approve on. So, first of all, the VC firms are typically probably going to be exempt from reporting under the CTA, but that doesn't mean that they're exempt from being reported as a beneficial owner or an individual who has substantial control of that startup. So I think that's an open question that we haven't looked very deeply on, but but at a surface level, those restrictive covenants could potentially trigger a VC firm or a fund as being required to report under the CTA. Ross, do you have any other thoughts there?
No, I think that's a really good observation, is just this being mindful in the deal cycle of that covenant in your SAFE agreement might trigger a FinCEN reporting obligation for the debt or the lender under the SAFE, if you will. The other thing is the CTA in conjunction with increased funding at the IRS. Having entities is a lot, they are much more like a child instead of a dog. They require lots of care and feeding, annual maintenance, and you can't necessarily just hire someone to take care of them. And so I think whether it's, there's this sometimes this mantra in the startup system that I'll deal with it later. Having an entity that didn't get its CTA filing correct on day one, that holds some intellectual property, and then it's got these fines that have just naturally accrued, it's a lot harder to unwind and manage that situation. Whereas previously, I think we had a lot of capabilities and ways to deal with sort of defunct or problematic entities. So I would just really stress to people that maybe LegalZoom is not going to quite get you where you need to be, and it's worth being willing to spend some real resources to get it done correctly upfront and early, and then to keep it updated correctly. So there's a question in the chat just about homeowners associations. Yeah. So it would be nice if they would clarify this with an FAQ, but since a homeowners association is not a 501c3, if it registers with the Secretary of State, it would appear to require reporting under the CTA.
Any other questions from our audience today? Feel free to speak up. Ross and Tyler, do you have any final words of advice, anything that if folks walk away today that you really want to drive home with them, that they carry away as they think about the Corporate Transparency Act?
Yeah, I mean, from my perspective, the Corporate Transparency Act is the new normal when it comes to having or owning or managing a business. This is something that we have to pay attention to. And if we don't, there are potential real consequences here. So again, like I said earlier, don't sleep on the CTA is what I'd say. Ross, anything else from you?
I think that's well said. I just thank you, Christina, for hosting this event today and facilitating it. And I think it'll be available if others want to attend or listen in on it. And Tyler and I are available too if you want to reach out for any questions. Thank you. That's
great. And is it okay for us to share your slide deck with the folks who've registered for this event today?
Absolutely. And I'll shoot you too. We have kind of a 2-page handout that we're happy to have circulated that kind of provides our best distillation of the implications of the act to business owners.
That would be great. Thank you. So thank you to Ross and Tyler and Parsons, Behle, Latimer for sharing your expertise today. We appreciate you co-hosting the event. So a recording of the presentation will be available online and also emailed to everyone who registered, along with the resources that have been mentioned. For a full schedule of virtual and live tech events in Montana, please visit mthightech.org/events. And thank you for joining us today.